That just helps my editing. Okay, legal issues. As I've mentioned before, I've spent close to 20 years now acting as an expert witness in litigation involving information technology. I have read tens of thousands, perhaps hundreds of thousands, quite literally, of emails over the past 20 years. I've read memos, I've read, testified in court, I've done analysis, I've done source code analysis, I've compared source code for possible misappropriation, and so on and so forth. And so I've seen just about every situation that an engineer. Now I will start with these obligatory disclaimers. I am not a lawyer. This is not legal advice. Legal advice, see a real lawyer. I am not offering legal advice. I'm simply offering professional cautions. Got 5 main areas. Unauthorized access, which may sound like, well, why would I ever access something unauthorized? You may not know you're doing it, or you may not think you're doing it. Oh, thank you, Windows. Okay, unauthorized. While it's deciding that it's going to collect some information and reboot. Let's start. Yes, it's blue screen of death, Windows 10.
That little frowny face.
That is a little frowny face.
It starts ranking before you get to Microsoft.
Yeah. Anyway, you have unauthorized access.
I can pull up the slides for you.
It's okay. This will be done in probably about another 2 minutes if that long. You have unauthorized access. You have misappropriation of intellectual property. You have involvement in a failed or disputed IT project. You have involvement in software that actually causes some form of injury or death, or just simply some form of loss, and taxing my memory. Come on, back up here. It's a little embarrassing that I just went through and did this whole thing this morning. I forget what the 5th one was. Oh, protection and discovery. Yeah.
You're going to give us examples of each of these?
Oh yeah. We're going to talk about each of these later. So, okay, unauthorized access, misappropriation of intellectual property, contributing to a troubled failed IT project, being deemed liable for software defects, and failure to properly preserve electronic data when necessary, which is an interesting one. Okay, here's the problem that you face. Back in 1986, Congress passed something called the Computer Fraud and Abuse Act. It has been revised and extended since. The problem is it is very vague, very broad, and has incredibly harsh penalties. It can be used for civil cases, that is for the basis of the company bringing a lawsuit against you, not just criminal ones. You'll notice here, first-time offenses can be punished by up to 5 years in prison or 10 years for repeat offenses. Violations for other parts of it are punishable up to 10, 20 years or even life in prison. This is Congress saying we're doing something about cybercrime. It's actually Congress creating carte blanche for prosecutors to have a very big sledgehammer to use over people. The point here is that if you think you're going to be a hacktivist and get in there and we're going to release these files and free them to the world, you could face some very serious fines and jail time. How many know who Aaron Swartz was? He's co-founder of Reddit. He's brilliant young programmer. Now there's a JSTOR, which is a digital database of academic articles, but it's behind a paywall. And he felt that these articles should be free, so he set up in a closet, he set up a private unauthorized connection to JSTOR and started basically releasing these paywalled academic articles to the wild. The federal prosecutors involved, he was caught, were threatening him with $1 million fine and 35 years in prison for having done this. So there was no physical harm to anyone. There was actually no economic loss to JSTOR. But that was their big sledgehammer. He hung himself. If you think you're being clever by, I'm going to break into these systems, I'm going to release this information wants to be free, you could pay a very dear price. The problem with CFAA, which is also the problem with the DCMA, Digital Copyright Millennium Act, and a number of other pieces of legislation, is that Congress does not understand computers. They have industry lobbyists come say, we want this, we need this, and they say, oh sure, yeah, let's put this in here. We'll pass this. And they seldom have people, let me put it this way, they seldom listen to people who say, wait, you really don't want to do this, these are going to be the problems.
Conflict neutrality, what?
Huh? Yeah. Congress can pass that anytime if they want. That's actually Congress's venue. And after Swartz committed suicide, which was in, I believe, 2015? 2014? Yeah. Maybe 2014. There have been repeated efforts to pass in Congress what's called Aaron's Law to basically eliminate this type of prosecutorial abuse. And it keeps stalling in Congress. I tried to look to see if it had ever passed, and what I kept seeing is, we're going to pass this, well, we've relaunched an effort to pass this, and so on.
Do we have a solution to that?
Do I? No, it's Congress. I have a whole thing about problems with legislation from a systems design point of view. So this is simply a caution, and this is often used in cases where companies are unhappy with you because they left. Aside from intellectual property, they may try after the fact to say, well, you were authorizing systems within our firm that you had no right to access. Like as an employee. There were no protections here, and it's like, well, you shouldn't have done it. So be very thoughtful about when you're in a company, where you're poking around, what you're doing, why you're doing it, and recognize that it could backfire big time on you.
If you're doing it for fun, become an ethical hacker.
Yeah, but with ethical hacker, you actually know what you're doing ahead of time. Unfortunately, part of the problem is you have people who decide to be, well, I want to show this company that they have security flaws. I'm going to go in on my own and do this. And guess what they get prosecuted under? The CFAA, because the company didn't authorize them to do that. And what you never want to do, and I'm amazed that I continue to read these news stories year after year. But I do. I'm sure I've seen at least one or two this year, where you have someone, usually a system administrator, sometimes a programmer, who's unhappy, is either quitting or getting fired, and plants logic bombs, basically, or changes all the passwords, and shuts the company out, thinking, and I'm pretty sure like 100% of the cases I've seen, it's a he. Sort of like, yeah, I'm going to lock this up, and they're going to be sorry I left, and this is going to be a big mess for them, and so on. And guess what happens? They get prosecuted under the CFAA. They go to prison. I read a couple of stories like this every year, and it all ends the same. They face fines, they go to prison, and it's just stupid.
There are some bug bounty programs that companies do have where you can hack them.
Well, yeah, yes. I do want to say, companies will encourage you to do stuff, but the point there is you're doing it with company authorization.
Yeah.
Big difference between doing it with company authorization and taking it upon yourself to do it because you want to show someone or you want to demonstrate, the system's really unsafe. I'm going to show the company, but I'm not going to tell them until after I've done this. Don't do that. Don't do that. No good will come of that for you. Company will gain from what you've exposed, but there's a good chance you will, at best be fired and at worst maybe criminally prosecuted. Okay, intellectual property infringement or theft. This is, I've watched over the past 40 years, this is a multi-trillion dollar issue worldwide. And you have 4 main categories. Trade secret theft. What's a good example of a trade secret? There's a classic one.
Coca-Cola.
There you go. You all know it. Coca-Cola recipe is only known by 2 people at any given time. I believe Coke has it set up so neither one knows the full recipe. They have to work together to proportion it. To qualify as a trade secret, the trade secret has to be intrinsically valuable. It has to represent a significant investment of time and money, and you have to show that you have taken the proper steps to secure and protect it. You know, NDAs to the employees, proper digital and in many cases physical security, so on and so forth. I have testified in a number of trade secret cases. I've worked on several more. The biggest problem with trade secret cases is the company that's claiming the trade secret has to define what the trade secret is. With Coke, it's easy. Well, it's our formula. When you're starting to talk about a software company, it becomes very tricky to say, well, this is a trade secret. Well, no, it's a quicksort routine. Well, but we're using it in a special way. Well, no, it still doesn't quite rise to the level of quicksort. I can go up and pull an algorithms book off my shelf, and there's the quicksort algorithm. What's the standard, and this is rhetorical, I'm not asking the answer. The standard pattern for trade secret cases I work on, it's 1 or more programs go from company A to company B and start working on a program that is similar to or somehow competes with what they're working on in company A. Company B says, wait, they took trade secrets. They have proprietary information about our software, what we're doing, what our market is, what we found through our market research. We have lots of sweat of the brow investment in these concepts, and they're profiting by it over there. Sometimes it's a legitimate case, sometimes it's not. Twice I have acted as a neutral expert in cases like this, where I've gone in and actually done source code review on both sides and come back and said, nope, their software is quite different. I don't see anything they really borrowed or made use of. I have seen other cases where it was actually pretty blatant. I've actually won a trade secret case at trial by listing 28 aspects of my client's proposed business process / system and showing that the defendant had no internal documentary evidence of any of those prior to meeting with my client, but within 4 months had 24 of the 28 listed for an internal project which could start up after they met with my client. But even there, the judge, after the trial, my client won at trial, but the judge issued a judgment of the matter of law that while there was infringement of intellectual property, there was no trade secret established because of inevitable disclosure, which is to say as soon as either my client or the defendant started to practice this, the aspects would be so exposed that it would no longer qualify as a trade secret. Big thing to be aware of here is if you change from company A to company B and they're in the same marketplace, don't take stuff with you. I was just approached with a new trade secret case where it wasn't even a technical person, it was someone in marketing was leaving company A and going to company B, competing company. What did he do 2 days before he stopped working company A? Plugged a USB drive into his laptop, his company issued laptop, copied about 1 terabyte worth of files over onto it, all from company servers in-house, and then unplugged it. And in the complaint, company's got the digital forensics. I've been through computer forensics training. Got the digital forensics saying it was plugged in at this point. At this point, these files were accessed from the various servers. At this point, he unplugged it from the thing. It's like, this is just stupid beyond words. And the company went to work for, I don't know, I haven't actually hired, I don't know how much he actually shared with the company, but that's like poison fruit. You hire someone thinking, well, we'll get their experience and advantage, and he comes over with a terabyte of files that he should not have. I've actually worked for a similar case. That was a software case. I think I mentioned it. 5 programmers went over, and one of them, unbeknownst to the company, brought over a CD-ROM of source code and used a small portion of it to save himself 2 weeks of work and ended up being a multi-million-dollar lawsuit. Yes?
So if you are a company and you hire someone and then you later discover after hiring that they have data they shouldn't have from the previous job, what should that company do?
Ask your lawyers. It depends. In the software case I just mentioned, they kept them employed because they wanted to keep them working with their lawyers. What they did, they hired me, and they wisely hired me very early on because they said, we need to know if any of the software shows up in our actual shipping code. And I had some custom programs I wrote to do fuzzy comparison. I was doing it between 3 million lines of code and 5 million lines of code, so it was 15 trillion comparisons. I actually went out and bought 2 PCs and divided up the work, and they ran for about 10 days. And I found third-party code. That was third-party code. I found code that one of the programmers actually had created prior to working for Company A, had used at Company A, and had used at Company B as well. But then I found the section of code wasn't a lot of code. It was IBM DB2 SQL parsing stuff. But it had identical English language comments in the same order, which is deadly as far as software copyrights go. So I went and told the company, well, I actually told the lawyers. I said, yeah, there's about half a dozen pages of copied syntax parsing stuff here. And what they did exactly a smart thing. They said, do you not have another expert you can recommend who hasn't done any of this? Who looked at any of this? I said, yeah, I mentioned Ed Jordan, who I know. They hired Ed Jordan, who set up a clean room reverse engineering effort with programmers who they could certify had never seen the Purloin code, had never worked on any of the poisoned product code out there, and he developed a specification for them, basically saying, well, it has to parse IBM DB2 SQL commands. And they wrote that from scratch, and by the time it came to a preliminary injunction hearing, my client could say, yes, Your Honor, we acknowledge that this happened, but by the way, we have already rewritten all the offending code, and we've already shipped updates to all our customers. There's no one out there who's using any of the misappropriated code. And by doing that, they saved themselves a world of trouble. Yeah?
How long ago was this?
This was about, I was in DC, I want to say around 2003, 2004. So, yeah.
What would typically happen with that one where a previous engineer had made it at a company, then they brought it in to company A, or had made it on their own, then they brought it to company A, then to company B? How would that normally work?
Well, if you're smart, if you're doing that, let's say you've got these great tools that you've developed on your own and you get hired by a company. You say, I've got these great utility libraries or tools or whatever, and I want to use them. You need to disclose that to them up front. Say, by the way, this is stuff I created on my own before I ever came to work for you. This is what I've got. Sign a document saying this is it. Because it can't really prosecute you. I mean, as long as you can document that it existed prior to you came to Company A, it's going to be an uphill battle for Company A to somehow claim they have intellectual property rights to it. But it's better to get it in writing, yeah.
Okay.
It's always better to get it in writing. If you've got stuff like that, when you go to a company, say, by the way, here's what I've got. And particularly if you're now going to Company B and you're using code that you developed before Company A and used at Company A, you should disclose that up front to Company B. And say, I've got these tools, these routines, these libraries, whatever. I developed them before I went to Company A. I'd like to use them here, and the company may simply say no. Company said, we don't want any trouble here at all. If you use them at Company A, you can't use them here. And that would be a good protective move on the part of the company. This comes to the software copyright infringement, literal and non-literal copying of source code, design, architecture. It is possible to do non-literal copying of source code. Classic case here is Computer Associates versus Altai. Programmer went from Computer Associates to Altai, took with him the source code for a particular program that Computer Associates was selling, rewrote it in a completely different language. So it was no longer literal copying. The copyright is on the actual expression. So he wasn't using the source code. He simply rewrote it in a different language, and as I recall from the case, a fairly distinctive different language. But nevertheless, CA sued and won, and it established a legal standard for non-literal copying of source code, which is called abstraction, filtration, comparison, AFC. Briefly put, AFC, abstraction says let's look at each of the different levels of the software: architecture, design, implementation. For each of those, you filter out things that have other excuses. It's mandated by the environment. In other words, I can't sue you for using a particular sequence of routines to access Linux or Windows, because that anyone who's accessing a particular function, Linux or Windows, has to do that. Efficiency. If you know, I have a if a certain thing takes 5 steps and I use it in 5 steps and you use it in 5 steps, and it's in essence the same thing, again, that'll get filtered out. So that there'll be more of an argument there. Basically, stuff that's available publicly. This is the quicksort routine. Okay, you know, you clearly copied our code because you've implemented this quicksort routine, and you even use the same variable names. You said, yeah, but it's a quicksort algorithm, and that's my naming preference. Cases like that, in theory, that should get filtered out. Though there's some interesting issues there. So again, basic thing is be very careful what you take with you when you leave the company. It could get you into big trouble. Patent infringement. You know, trade secrets, copyright, and patent are the 3 main legs of intellectual property in the U.S. Patent infringement. Patent is basically a time-limited license monopoly by the government. You create an invention, you file for a patent. If the patent is granted, then you have an exclusive right to use and or license that invention for the duration of the patent, which is, what, 17 years? I should know that, but I think it's 17 years. A lot of my patent infringement, and in this case, you could be completely innocent in the sense that you could come up with, hey, I've got this nifty solution to this particular problem. And someone who owns a patent says, wait a second, they see your software and say, that looks like that's doing what we do, and it probably does it in the same way. You get into patent litigation, which is incredibly expensive, and I've done a number of patent cases. And you have someone like me who's hired who looks at the allegedly infringed claims in the patent and looks at the source code and says, yes, that actually is doing just what the patent says. And if that's the case, even if you invented it independently, you cannot continue to use that. And there can be damages if the other side can prove that you should have known about the patent, which is always a tricky issue.
So if there's no way you could have known, or
Yeah, even if there's no way you could have known, you'll simply be enjoined to say you can't do that anymore.
yeah, but you don't have to pay.
Not necessarily. It'll depend.
Legal fees, no.
You'll still have and patent litigation is very expensive. This is why a lot of companies settle. You have the patent trolls who buy up patents, and they go around suing people for anything that even begins to resemble it. And because litigation is so expensive, a lot of companies will simply write a check for $500,000. Say, yeah, go away. I'll buy a license for your patent.
It's usually like law firms that do this,
Oh
right?
yeah, oh yeah. There are indeed. License infringement. And this is an area that's just gotten messier and messier over the past 40 years. Because there are inconsistent and conflicting rules as to what you own when you buy something. You have the issues, and I'm not going to give you a lecture on some of the laws here, but the point here is be careful in appropriating, either for personal use and especially for professional use, other people's digital creations that would normally be licensed, whether that's software, music, images, games, movies, whatever. Yes?
An interesting case of that is with Stack Overflow, I believe everything that was posted before 2016 at some point is licensed under a share alike license, including the code. So if you copy paste code from Stack Overflow that's like that old, you are technically obligated to publish the code that you put in under the same license, which is really messy and nobody does that. But it's an interesting, and they changed it probably for that reason because nobody follows that. So they changed it to it's more like MIT-like for the source code. But it's an interesting case like where most people don't even think.
Wouldn't think about copying. It's like, oh, hey, here's the answer.
Right. It's on Stack Overflow. Just use it, but you can't actually do that.
And I would normally say that the code snippets are so small that it wouldn't matter, but then you have the Google versus Oracle case, where you've got a fair use argument over a relatively small chunk of code that originally was denied protection, and now on appeal the protection has been reinstated. It could have some very ugly consequences by the time it settles out as far as what's considered fair use within software. Yeah.
How small chunk of code are you talking about?
I think it was a single routine. I would have to go back and look. It was a pretty small chunk of code.
I think it was like a bunch of, I think it was like 3 or 4 small chunks.
routines, yeah.
And they were just like things that were so small that
Yeah.
it could be argued that if you were to just re-implement this from scratch, it'd be the same.
Yep. So go Google, which is another cautionary tale. If you are, yes, go Google versus Oracle. Even though Google will immediately take the Google out, so put it all in quotes. The which is another practical concern. If you see code snips, give them your own variable names. Seriously, folks. Pro tip: give them your own variable names.
Forget about the comments, rearrange.
Yes, and delete all the comments, because that's the deadliest thing. If you have the identical comment in there, it's because there's no good reason for you to have exactly the same comment.
Exchange the if-thens with the switch.
Whatever you want to do. Yes, be careful what you copy and how.
Just rewrite it in different
Be
language.
smart about how
Yeah.
you copy it.
Though, as I said,
Yeah, plagiarize effectively, people.
there you go.
There's an interesting, some sites that have code snippets do require that if you post a code snippet, that it has to be,
Released to public.
it has to be released to the public. And so I think Stack Overflow, it just requires attribution and that's it.
Yeah. And see, it used to be, you'd buy, I have at least half a dozen books on my bookshelf, mostly from 30 years ago. It used to be a big thing to buy books of algorithms. Of course, this is pre-Stack Overflow, it's pre-web. And the whole reason you bought the books of algorithms was so that you could look up and find an algorithm and just put it in your code. There was heavy use of such published and public domain code. It's much trickier now. Okay, contributing to a troubled, failed IT project. New subject for all of us, right? This is usually something that you don't find yourself individually in jeopardy over, unless, of course, you're a one-man project. You go in and promise to deliver someone some software and you fail to do so. But this is usually on a company basis, but you can find yourself involved. You may be deposed. You may be asked to testify at trial as a fact witness. Your emails and memos, things you produce, may be used as evidence. We have talked about all the reasons why projects fail. What do you do if you find yourself on a troubled project? Raise issues early and often. Raise your hand. Make sure the company can't come back and say, well, they never, so-and-so never told us that. So make sure you told them. Now, here's the tricky part, where I say, if necessary, document for yourself, to your superiors, to the other party. To the other party means if the other party is causing the problems. And this is one of the big failures I see in two-party lawsuits like this. You have company A, you have the developer and the vendor. The developer and the customer, excuse me. Developer is developing a system for the customer. And problems arise on one side or the other, or sometimes both. And let's say the problems are arising with the developer. The customer will be like, oh, we want to be nice. We're not going to actually say anything negative. At least not in writing. We'll do it on the phone, but won't write anything down. Bad answer. Ditto if the roles are reversed. You're the developer. The customer is not giving you the information you need. They're not providing access to people. They're not providing access to their systems. And you want to be nice because you're there. You're the one selling to them. It's kind of like, oh, well, we'll raise it on the phone, but we won't write it. Bad answer. What happens? You go to trial, and the other side says, well, you guys never said anything about it. Look, we're looking at our emails. We're looking at memos. We're looking at letters. There's nothing. Well, we talked about it on the phone. Well, we dispute about what you said on the phone.
That's why you're recording it.
That's why, yes.
If
Now,
anyone of the parties did.
the problem here, and this is what you want to watch out for as engineers, is your internal communications. There may be cases where you do want to document things internally, particularly if it involves the other side. But what you don't want to be is like the engineer, though I liked it. One of the first cases I worked on was a failed project developing a vacation booking system for a subsidiary of American West, and I was on the side of American West. And we had emails from the developers, internal emails from the developers on the developer side, saying, I can't believe we're charging the customer $100,000 for this garbage. Okay, that's a great email if you're on the other side. It's like, hey, yeah, look at the time frame. This guy's, he's one of the programmers. He's saying what they're trying to deliver to us is garbage. As engineers, we tend to be passionate and we are always quite honest, which are good qualities in an engineer. But as the saying often, as I've seen this make the rounds quite a few times on social media, email is as if it would be read out loud at a deposition. Any email you send, assume it could be read out loud at a deposition. And in circumstances not necessarily favorable to you. Because trust me, I have personally been deposed a lot of times, but more than that, I have sat through a lot of depositions, and that's exactly what you want. So, Mr. Jones, in this email you said that you were delivering garbage to the customer. This is on June 5th, 2003, just before you were delivering your next release to American West. Can you tell us what you meant by delivering garbage to the customer? You don't want to be in that situation in deposition. Yes?
The advice that was given to me was don't send anything internally that you would be embarrassed being on the front page of the New York Times.
Yep, that's perfectly fine. And I've been guilty of not doing that, and I almost always regretted it. I can think of a few particular instances where I've sent off emails and caused far more problems than I thought I would have caused. One was in about 4 years into Pages, where there are some real issues going on. We're doing some layoffs and so on, and the VCs had asked me, let's see, what was it? No, I think it was something I actually sent to Larry. I was very frustrated with him about something. I just said, I don't know if I can stay with the company. And that set off, that I did not appreciate that as Chief Technical Officer and Chief Architect, sending that to the CEO of the company, he was under a fiduciary responsibility to disclose that to the investors, who then, of course, got extremely concerned, since they had $7 million in the company, that I might be walking away, and it caused far more problems than I thought it was going to cause. So,
What problems did it cause for you?
well, the basic problem was
Scared off the investors.
well, they kept investing, and I ended up staying. But it significantly damaged the relationship between me and Larry for that last year. And I like Larry. There are a lot of things I disagreed with him about, but I actually liked him, and it made for an awkward working relationship for the final year of Page's existence. So. Okay, being deemed liable for software defects and failures. We've had 2 recent fatalities of self-driving cars. I would not, and there are arguments as to what all the factors were. The Uber one, and I think it was Arizona, it actually looks like someone at night deliberately stepped out right in front of the car. However, there's a Tesla one that just happened that looks like the autopilot was engaged, and it may have been the autopilot was not correctly processing things. Obligatory point, I'm very skeptical of self-driving cars. People hype it a lot. I'm very skeptical of them.
They've been tested somewhere where it snows.
Yeah, well, there are all sorts of tests I can think of for self-driving cars. I think the rush there is a little fast. I'm happy to be proven wrong, but we'll see. Volkswagen. How many know about the Volkswagen defeat device? Volkswagen put code in its diesel device. It had a big push to sell more diesel vehicles, cars and trucks in the U.S. But the problem were the emission standards here. So they put code in the car's systems that could detect when the car was set up in an emissions testing situation, and it ran the engine different to reduce emissions. It also reduced efficiency and all sorts of other things. And then out on the road, it wouldn't trigger, and the emissions levels were vastly higher. And this was discovered, and Volkswagen ended up paying $14.7 billion to the U.S. EPA
Now, how much profit did they make from this?
for that. I'm not sure they made $14.7 billion. They could have, but they're also under a number of restrictions and so on and so forth. Okay, how often do you see a thing in the media that says, "Oh, the whole customer database for company X was just leaked out to the internet"?
Twice a week.
Yeah, about twice a week is right. It's a little scary. There's actually a site, you've been pwned, that you can go to and type your email address into, and it'll say, okay, here are all the places where your information's been leaked.
Is that Have I Been Home?
Yeah, have it
Yeah,
pwned.
check something really quickly.
If you like.
I'll have to check that.
There's a great forum for, there are issues in which software has been known to harm or ruin people or even kill them. There's and I don't know, oh, I'm embarrassed because I just forgot his name, long time. I want to say Philip G. Newman. Someone with the ACM has been running a software risks site for decades. And one of the most famous cases from about 30 years ago was a radiation treatment for cancer patients, thing that like targets tumors in your brain. There was a software bug that basically had it emit several times the amount of radiation it was supposed to actually emit, killed the patient. I've analyzed software in a patent case for devices that fill you with tracer elements for MRIs. And again, there are cases when you're talking about medical equipment, when you're talking about flight avionics, when you're talking about, now we're talking about self-driving cars, things where you have a life and death situation. Software errors, software defects, or frankly just insufficiently thought through design can cause great problems. Yes.
How does that compare in court of law compared to human error? Like if because we know that even if there are the occasional accidents with software, for example, self-driving cars, people crash into people all the time, kill people. How do the two vary in court?
That's actually a very good question, and I have no idea. Except for this, there's a difference. It's a difference between if you have a driver who fails to hit the brakes or hits the gas instead of the brakes and crashes the car, that's one thing. If I'm a car manufacturer and my brakes fail, I have actual liability. It's not human error, it's actual liability. So with software has become so pervasive that you start to run into situations where the company is liable. And again, as I say, this will tend to be at a company level. But once again, you can be dragged into it if you're the person who happens to be working on that code, especially if you're the person who introduced that error or failed to take the steps necessary to protect this. So this is a situation where if you're working at a company and you see these problems or defects, raise the issue and document it to protect yourself. The company probably won't want you to document it. You need to document it to protect yourself.
But not too aggressively, so you don't end up in another set of problems.
Well, there is that, yes.
So, what do you do if you're suspicious about like the company like tampering with your documentation? Like if I email myself something internally, and I know.
Oh, I would keep all my copies offline. I would print them out. I would, copy them to a flash drive and take them home.
Okay.
I would protect myself that way.
Okay.
Okay, this is an interesting one. And it's been fascinating for me to see how much has changed in 20 years. When I first started doing expert witness work, I'd get hired by a company and I would receive from UPS 2, 5, 10, 20 boxes of documents, all printed out that I would have to go through and read. And what I've watched over the last 20 years is the move to digital, not just in the documents produced in the company, but in the documents as they're actually, or documents produced in litigation, but the documents in the company themselves. And this has become a big issue for companies involved in litigation. Discovery is a process which I'm sure most of you have heard. In essence, it says that in litigation, and frankly in criminal trials as well, but particularly in litigation, each side has to produce any relevant documents to the other side. Now, when you only had physical documents, it was pretty easy. You hired a company that came in and Xeroxed everything in your filing cabinets and in individual file folders for your employees, and that was fine. Okay, now you have companies that have terabytes of data. And they don't necessarily want to produce everything. And so first you have these big arguments over what they do or don't have to produce, and then they have to figure out where it all lives because stuff gets replicated. I have sets of files that are probably replicated over half a dozen hard drives among all my various systems. It's backup media and so on and so forth. And then you have to sort through these and figure out what's there. Now, here's the problem. Here's the classic case. American Home Products was a company making fen-phen, a drug that was a weight loss drug that got tied to pulmonary hypertension. And they were ordered to produce all their internal emails for a certain period in question. The problem is that the company had a rotating backup thing where they were backing up their email server onto tape, and they were rotating the tapes on a 4-month basis. And this rotation had been continuing to happen as the litigation was starting up. And when the company actually got the discovery order from the judge, they said, well, we really only have 4 months of emails. The rest because we recycle our tapes on a 4-month basis. And the judge says, you were supposed to preserve documents as soon as there was a possibility of litigation. It's not just actual litigation. a possibility of litigation. And the judge issued to the jury a finding of spoliation, which says you are to assume that American Home Products deliberately destroyed those emails because they would be damaging to their case. American Home Products lost the case and I think pretty much went out of business. So, companies since then have been more careful about their data retention policies. They will often have one that says you need to delete emails after so many days, 30, 60, 90. Sometimes they'll do it for you. If you're preserving emails that are older than that without telling them, recognize that if there's litigation, you'll have to produce those. If you're in a situation where you're involved in system administration and you know that there is litigation or a threat of litigation, you should take steps to say, okay, wait, we need to avoid deleting anything here because otherwise we could be in big trouble with the court. And don't write emails that say, wait, we need to delete everything real quick because we might go to litigation. Don't write those. I've seen.
If you do delete it.
Yeah, if you do delete it, but you'd be surprised what can be recovered. Again, we're back to computer forensics, and often when you're when you know there's like a few specific computers involved, simply continuing to use that particular computer can be considered spoliation. It should be unplugged from the wall and set aside, or you can image it and then start working on the image. Or have someone come and take a forensic image at that point. There are a number of things you can do, but
Typically, you take out the hard drive because that's where the evidence is.
yeah, though technically for good forensics, you literally pull the cord, disconnect it from the wall, and then there are forensic devices that can go in and do a write block and do a bit image of the hard drive while having completely disabled any effort by the drive to write on itself. And then all forensic work is done on the bit image. You never go back. You never work on the original because stuff can change there. And there's a whole host of programs where you can do various forensics and recover stuff. Like I said, I've been through about 120 hours of forensics training. I just never finished my practical, or else I'd be certified in that. Okay, summary. IT is where a lot of the most interesting legal issues are, and a lot of the most interesting complications. And there will be new ones that will develop over time. I've watched them over the last 20 years, and they have gotten very interesting and very complex. One of the things that I wrote in an article several years ago called IB Ubiquity. How many of you ever read The Demolished Man by Alfred Bester? Great classic science fiction novel from the 50s. In this, it's a case where there's no crime because they have telepaths who can basically see into your mind and see everything. And it's about someone trying to commit a perfect murder in the case of that. We're approaching something of the situation where we leave so many digital traces online, on our devices, that we can be tracked on an amazing basis. You think of emails. How many of you think of your texts, your instant messages as discoverable? I have been in trials where there have been instant messages with timestamps from a couple of years earlier that have been recovered. Here's something, I can't remember if I mentioned this to you. But this should put, this sort of chilled me. I have a case I'm working on here in Utah. It's a wrongful termination case. The whole story is complex. Basically, my client is a woman who claims she was wrongfully terminated. The company that fired her claims she did not show up for work on these two particular days back in 2014. And when I was retained, the lawyer said, we have this location services information off her phone. And I looked at it and said, well, this is nice, but it's XML. It's a text document. I said, I could type this. I said, what you really need to do, for me to do anything on this, I said, there really isn't much I can testify to other than say, well, this shows this. And I said, if I were on the other side, I could demolish that argument. I said, what you really need to do is get something straight from Google. About 2 months later, the lawyers send me a document. It's from Google. It has 65 pages of location information covering 3 days. Latitude, longitude, margin of error, device being tracked, timestamp. And I was like, whoa! And I took these and I sat down with Google Maps and I traced it. It's like, yeah, here she is driving home. Here she is at work. Here she is going to this place. Here she is going to that.
Oh, that's terrifying.
And this was, I mean, stop and think. There's like 2 billion Android devices in the world. This is from, at this point, almost 4 years ago. And Google still had on their servers that detailed information. Basically, roughly 20 samples a day. Yeah.
If you've had an Android phone for a while, you can go back until 2010 on your Google Maps and you can see
Where you were?
everywhere you've been. It tracks the distance you've traveled and everywhere you've been.
Yeah.
That's
Google Maps timeline.
There you go.
You can look it up. I can look at, like, you know, the travel I did 2 years ago if I
Yep.
want.
Yep.
You can also instruct them to delete it.
Yeah.
Or to not keep it, but it is by default on and people should know this.
Yes, and that's exactly the point. So, but if, just, again, stop and think of the sheer amount of data that Google can hold on to. It's pretty staggering. Anyway, any last questions? Otherwise, I'll take roll and let y'all go.
What's your opinion on the Facebook Chamber channel thing?
I'm not at all surprised, and I think this is not an isolated case. People have been mining Facebook data heavily for as long as Facebook has been around. So I think picking one target is sort of like, well, yeah, that's not the issue. The issue is that Facebook is, as a number of people have put this online recently, the thing you have to realize about Facebook is the product is you. You are the product that Facebook sells. It's put ads in front of you, to put news articles in front of you, and to sell your demographic data to other firms. So, anyway.